First, we aim to strengthen the registration process. Currently, applications to register societies can be processed via two routes. The normal route is for applications that fall within the categories specified in the schedule of the Societies Act. These societies are involved in issues which are more sensitive, such as politics, religion, race, language, and nationality. Such applications go through vetting and assessment by the Registrar of Societies, which may involve several rounds of clarifications with the applicant. The registrar has the authority to reject applications submitted via the normal route. We also have the automatic route. It is meant for societies involved in issues which are less sensitive. For these applications, the Societies Act currently states that the registrar shall, without making any further inquiry, register these societies on the date the registrar receives the application, so long as the formal requirements for registration are met. In the last 5 years, we received about 1,400 applications. About half of them were submitted via the automatic route. This differentiated approach in processing applications has allowed the MHA to focus its attention on assessing the more sensitive applications. That said, there are two gaps. First, there were instances when the registrar needed information to ascertain whether applications under the automatic route indeed did not fall within the sensitive categories in the schedule of the Societies Act. However, the current law does not allow the registrar to seek clarifications of such applications. Second, even if an application does not fall within the sensitive categories in the schedule, it could still be of concern. However, the registrar currently has no authority to reject such applications. Clause 4 of the bill therefore amends Section 4A of the Societies Act to remove the obligation on the registrar to register a society under the automatic route without making an inquiry. This will allow the registrar to make inquiries of applications submitted via the automatic route and empower the registrar to reject an application submitted via the automatic route if the registrar is satisfied that the society, if registered, A, is likely to be used for unlawful purposes or for purposes prejudicial to public peace, welfare, or good order in Singapore, or B, would be contrary to Singapore's national security or interests. Clause 4 of the bill adds a new section to allow appeals to the Minister for Home Affairs for rejected applications via the automatic route, similar to the existing appeal mechanism for applications via the normal route. Clause 3 of the bill inserts a new section 4.3a to make it explicit that the registrar has powers to require the rules of specified societies to be amended as a condition for registration. The registrar can refuse to register the society if the society does not comply. Currently, under Section 11 of the Societies Act, societies need to seek the registrar's approval to change their name or amend the rules in their constitution. The Societies Act is silent on the grounds on which the registrar can refuse to approve such applications. To provide clarity to societies, Clause 8 of the bill amends Section 11 to include the grounds on which the registrar may refuse to approve a change of name or an amendment of provisions in the society's constitution. For example, the registrar can refuse to approve a change in name if the new name is likely to mislead members of the public as to the true character or purpose of the society. The registrar can refuse to approve a change in the constitution if it would be contrary to Singapore's national interests or prejudicial to public peace, welfare, or good order in Singapore. For ease of administration, Clause 10 of the bill amends Section 12(1)(b) of the Societies Act to allow the registrar, instead of the minister, to declare a person as unfit to be an officer of a society. The minister will be the appellate authority. Currently, Section 2 of the Societies Act defines the place of business of a registered society as the place where the records and books of account of a society is kept. This is too narrow in today's context where virtual offices and storage of documents on the cloud are common. Instead of place of business, Clause 2 of the bill amends Section 2 of the Societies Act to refer to registered address instead, defined as the address of the society that is kept and maintained with the registrar. The last review of the penalties in the Societies Act was done in 2004, 19 years ago. We are increasing the fine quantum for all the offences in the Societies Act to keep up with inflation and to ensure that the fine quantum continues to have a deterrent effect. In addition, we have updated the offences of providing false information to the registrar. Clause 15 of the bill introduces a new Section 30A to allow the registrar to compound offences in the Societies Act as an alternative to charging offenders in court.